It's January the 3rd, 2012. I'm Mike Benedetti, here with Carmen Trotta. We are in a kitchen, but we're not eating. Today is the first day of 10 days of fasting in action for closing Guantanamo, ending America's policies of indefinite detention. Unfortunately, once again, Witness Against Torture and many other groups are here in D.C. spending early January working on this. Carmen, how's it going?
We had an interesting day in court.
Okay,
I should say one of the things in your introduction left out was that we are approaching the 10th year of Guantanamo's existence.
Yes.
It's a metastasizing cancer. As I understand it, just today, President Obama signed legislation in which Congress, by the accounts of all the human rights group, has given the president the power to detain Americans without charge or trial on no evidence at all.
That's right. And we should point out, too, that also today is the first day of a trial, a civil disobedience trial. This dates back to, June the 23rd?
June 23rd.
June the 23rd, 2011, a group of people went up into the visitors gallery at the Capitol, and at a time when the congressmen were sort of, had finished their debate and were then voting on something, one at a time, these people in the gallery sort of spoke out to the hundreds of Congress people down there about the issue of Guantanamo, and eventually these guys were removed and arrested for disrupting Congress. I guess 14 people were arrested initially. The charges were dropped against a lot of them, and now 4 people are on trial? 5 people are on trial. So today was the first day of the trial. It was a jury trial, which is a little uncommon for these kind of civil disobedience things, right? And this
very uncommon in my lifetime. I've never faced a jury. It's an interesting, and we're quite thrilled.
Yes, and this is also, the charges of disrupting Congress are fairly serious, right? I mean, you could get 6 months in jail. I mean, not serious, but
I don't know what the jeopardy is. I don't know what other people have gotten. I think that's the most they can give you.
Okay.
And I'd be surprised if I would be surprised if most of us receive 6 months. I would be entirely surprised. I would be surprised if I received 6 months, and I have a.
Sure. So today people went down to D.C. court, and then you had jury selection, and then how far did you get into the trial? You had opening statements and things?
We both did openings, and the prosecution began their case with their first witness, who was one of the guardians of the House chamber.
And people aren't disputing that they were there. People weren't disputing that they were saying things. Is that right? I mean, you guys are not.
No, and it's unusual the way that they've proceeded. Well, I wanted to object because the presentation was so boring. Of course, their case.
You can't object to court being boring.
I wanted to try. I wanted to try on the basis of saying that what they were doing was irrelevant, and what they want to convince the jury, both the judge and the prosecutor want to convince the jury that what this is about, this has nothing to do with Guantanamo. This has absolutely nothing to do with Guantanamo.
Right.
And what this is about is whether or not we, in fact, engaged in disorderly conduct with the intent to disrupt Congress. And we're arguing against that charge.
Okay.
So by speaking out is what they're calling disorderly conduct. And we are simultaneously arguing against that charge, because you're always denied an affirmative defense, whether you want to have a necessity defense or a defense based on national law.
This would be a defense which would basically say that the crimes of indefinite detention in Guantanamo are huge, and we've tried many things in the past, and we're trying something else to try to deal with these crimes, and so you can't really.
Actually, we said right.
You should acquit us because we were doing something that we were trying to solve a problem of huge magnitude.
Yes, and I actually think we have a case, in part because we have a jury. And I tried, because I gave our opening this morning, and I was very limited in what I could say by the judge.
They said you can't talk about Guantanamo, you can't talk about this. This is just about you guys being.
The judge actually preemptively demanded that I share with him the content of my opening remarks before he would allow me to present them to the jury. Once I presented them to him, he said you can't say that to the jury.
Really?
And we argued back and forth. He's a Judge Fisher. He's a nice. He's sort of a fine fellow. And we had an interesting interaction with myself and my attorney advisor and the judge and the prosecution. And ultimately, it was a question of, there were some people who were convinced that I was going to get angry and pop off and just begin arguing. And the group had really talked about this. So what if they shut us down, and wanting to kind of proceed forward and not bog down in our opening statement.
Right.
And there was a way to make the opening statement without, if you spoke just to the charge. And I think what I managed, and I'm happy to say, I think I managed successfully to give the jury some idea of what the case was really about. So, for instance, the prosecution has, at least in my mind, made a mistake because they have, one of the things that they asked the jury, they told the jury when they were interviewing jurors, when they were going to delete jurors or save jurors, in their questioning of the jurors, they said, this case is about Guantanamo in protest, the prison at Guantanamo.
They told them this
protest.
when they were doing jury selection.
Jury selection. So, given that was already done, I didn't have to mention, I was going to speak of details about Guantanamo, but I didn't have to actually mention Guantanamo. Because the prosecution went first and essentially said, here's what this case is about. It's whether or not they did this. When I went, I said, you know exactly what this case is about. And I repeated that a couple of times. Yeah. And I'm certain that they got it. And I talked about that what the case was about was that we had gone to petition our government for redress of grievances, and that the grievances were multiple and grave. And they allowed me to say that. I didn't mention Guantanamo. And that we had spent the last several years, as you know, every year since 2007, we've been in Washington, D.C. We've done quite a bit, particularly recently, of direct lobbying of senators, of congresspersons, of going into their offices. When you go into a senator or a rep's office, you very rarely, almost never, see the rep or the senator. You talk to some graduate student who's very charming and assures you that they will relay your concerns to the congressperson or the senator. And we have never had a substantive response come from just about any one of those visits.
I actually have, but yes, in general, not a lot comes out of it.
I'm trying to remember the best of the reps.
This is outside the scope of this video, probably.
I'm sorry?
This is probably outside the scope of this video. So anyway, so you said to the jury, you know what this is about. You've already been told what this is about. Whether or not you, Carmen, are allowed to say what it's about, they know what it's about. And so the idea here is that all 12 of the jurors would have to agree that you guys are guilty for you guys to be guilty. Is that right?
That's correct.
So that it's an interesting to have a jury trial because not only if there's one person who if there's anybody who is sympathetic to the idea of jury nullification or the moral argument here, just one of those 12 people, that's enough to get an acquittal here.
Everyone should learn this. So I was part of jury selection, and we decided to go very low-grade jury selection. We were going to disqualify only the worst candidates. Mm-hmm. Otherwise, some of us actually wanted to allow anyone on. I think it's good that we didn't. We did disqualify a couple of people. Yeah. However, unfortunately, the progressives, the real progressives, and there were three of them, who almost certainly would have nullified, but they disclosed that they would probably nullify.
Right.
And
so it's not just 12 random people. It's 12 people. It's 12 people who've also said it's 12 people who've indicated that they're not sympathetic to the idea of jury nullification. But still.
No, they haven't. If they'd admitted that, they'd be out the door. They.
That's what I'm saying. That these are 12 people who were asked, would you be interested in acquitting these guys just because of the issue of Guantanamo? And they were like, I would just look at the evidence. They say that, right? I mean, this is the kind of thing that they say during. I wasn't in the trial.
There are really good, thoughtful people, and we lost one of them who say, either, I'm sort of opposed to it, but I could go either way depending on what the evidence shows me. And they're really very good, thoughtful people on both sides. Some of them who thought, there was one elderly gentleman And I wish he would have stayed. He seemed so very honest. He said, well, you know, what those guys did at Guantanamo was wrong. You know, they're getting theirs. But it talked to him a little more, and he was really quite open to hearing more about the issue. And he would have decided on the facts in his
Right.
own mind. And I would have had him. So we're very happy with the jury that we got, and they seem it's a very warm group.
So I guess we find out in the next couple of days what comes out of that, out of the trial.
Yeah, it could be very interesting. Yeah.
Yeah, all right. So we have a few more days of trial and then many more days of fast day in action. Now, I'm sure we'll be talking to you before too long, Carmen.